Come to order. Please call the roll.
Senator Rocky Adams, Senator Wilson, Senator Yates, Representative Bridges,
Here.
Representative Gordon, Representative Marzian, Co-Chair Lewis,
Here.
and Chair West.
Here. We have a quorum duly constituted to conduct business. First matter is the approval of the minutes. Are there any additions or corrections to the minutes? Seeing none, I'm assuming we have a motion from Senator Adams, and we have a second from Representative Marzian. Without objection, it's so ordered. Senator Wilson is present.
Thank
You
you.
have him.
I was going to say on the special guest.
Committee will stand at ease. Do we have any introductions of special guests or other business to come before the committee? Co-Chair Lewis.
Yes. Do we have the Deputy Commissioner of Natural Resources here, David Fields? Angie says happy birthday. Thank you for being here.
It's going to be a good day in at least one way. Happy birthday. We're going to go a little bit out of order. We're going to start with Finance Administration Cabinet, Kentucky Public Pension Authority, KAR 1451.
Public Protection Cabinet, Department of Financial Institutions, 808 KAR 3050 for informational review.
Wrong one. We're skipping ahead a little bit on you. 1451.
Sorry, Kentucky Public Pensions Authority, 105 KAR 001 451 with staff suggested amendment.
This regulation is being amended to incorporate the contractor wizard required for certain employers to report independent contractors and leased employees and update language for consistency with 105 KAR 1001. The staff amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A.
State your name for the record and please proceed.
Nathan Goodrich, Staff Attorney Supervisor, Kentucky Public Pensions Authority.
Thank you so much. There is a staff amendment. Do we have a motion on the staff amendment? We have a motion. We have a second. Without objection, so ordered. We have the reg in front of us with the staff amendment. Any questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Thank you.
Boards and Commissions, Board of Veterinary Examiners, 201 KAR 016510, 513, 515, 517, 730, 731, 732, 735, 737, 762, 765, and 767 with staff suggested amendments, 772, 775, and 777 also with staff suggested amendments.
201 KAR 16510, 513, 515, and 517. Update fees for veterinarians and establish fees for AAHPs, veterinary facility and AAHP facility registrations, including fee increases. The amended after comment versions all make changes to comply with KRS Chapter 13A and delete the provision that authorizes the board to increase fees if the carry-forward balance of the year falls below $200,000. Additionally, the amended after comment version for 16510 adjusts state ranges for various fees to match the fiscal year and decreases fees for an inactive veterinarian license from active status of less than 24 months from $650 to $550 and from $750 to $600 for specified date ranges. The amended after comment version for 16515 replaces some of the incremental fees, originally increasing over time at set dates, with a flat fee for veterinary facility and mobile unit licensing and renewal, including initial and renewal fees for 3 or more mobile units at $25 per unit and the veterinary facility renewal fee at $200. The amended after comment version for 16.517 includes a standard $25 fee per mobile unit if registering an AAHP facility with 3 or more mobile units, and replaces renewal fees for AAHP facility registration with a $200 fee. 201 KR 16730, 31, 32, 35, and 37 establish requirements relating to AAHP permits, including program and education requirements, exam requirements, application renewal and reinstatement requirements, and responsibilities and limits on practice for AAHP providers. The amended after comment versions all make changes to comply with KRS Chapter 13A. Additionally, the amended after comment version for 16735 adds continuing education for AAHP providers in the amount of 6 clinical hours annually from an approved program of the AVCA or IVCA, and requires legacy pathway candidates to earn the same amount of continuing education as traditional candidates, but with an option to obtain continuing education from a program approved by the board. The amended after comment version for 16737 deletes language allowing an AAHP to proceed with treatment after 3 business days without hearing from a veterinarian, adds that an AAHP and not the veterinarian is liable for any adverse outcome from the AAHP's work, and modifies terms required in an animal patient's medical record. 201 KR 16762, 65, and 67 establish requirements relating to veterinary facilities, including application requirements, duties of veterinary managers and responsible parties, renewal and reinstatement requirements, in addition to KRS Chapter 13A changes and clarity changes. The amended after comments version for 762 removes reporting requirements on local health departments and adds an exemption for veterinary facility registration for public rabies clinics and government-sponsored vaccine clinics for animals solely to prevent infectious disease, and clarifies that the application requirement that a veterinary facility report if it offers hauling installation only applies to livestock. The amended after comments version for 765 clarifies in Section 2 that hauling installation only applies to livestock. 201 KR 1672, 775, and 777 establish requirements relating to AAHP facility registrations, including application, renewal, and reinstatement requirements and duties of responsible parties and managers. The amended after comments versions make changes to comply with KRS Chapter 13A. The staff amendments for 201 KR 765, 767, 775, and 777 all make changes to comply with KRS Chapter 13A.
Sounds like the vets have been very busy here lately. Would you please identify yourselves for the record?
Michelle Shane, Executive Director for the Board.
Dr. John Park, Chairman of the Board.
Thank you so much. There are staff amendments. Do we have a motion for approval of the staff amendments? Representative Marzian has the motion. Senator Adams has a second. Without objection, is so ordered. Any questions from members on this lengthy set of veterinary regulations? Seeing none, please call the next regulation. Thank you.
Thank you.
Board of Speech, Language, Pathology, and Audiology, 201 KAR 017120, with staff suggested amendment.
201 KR 17120 establishes and incorporates by reference rules adopted by the Audiology and Speech Language Pathology Interstate Compact, including to break those rules down into 3 chapters: the Rule on Definitions, Rule on Data System Reporting Requirements, and Rule on Implementation of a Criminal Background Check Requirement. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record? Make sure your microphone's on the green button. Hold on. Is it green?
Green. Okay,
there you go.
My name's Sierra Sherwood. I'm a board member of the Speech Language Pathology Board.
And I'm Sarah James. I'm a board attorney for the Speech Language Pathology Board.
Thank you so much. There is a staff amendment. Do we have a motion for approval of staff amendment? We have a motion and a second. Without objection, is so ordered. Any questions for members on speech pathology regulation? Seeing none, please call next regulation. Thank you.
Board of Licensed Professional Counselors, 201 KAR 036050, 50 with a staff suggested amendment, 36-100 emergency with agency amendment, and 36-100 ordinary with agency amendment.
201 KR 36050 amends provisions to update terminology to be consistent with statute, establish a new section advising complainants that a release of medical records may be necessary under HIPAA, correct material incorporated by reference and include instructions for the use of the material, and incorporate a new medical release form by reference. The amended after comments version amends provisions to update the name, number, and date of material incorporated by reference, clarify requirements related to the submittal of a complaint, and make technical corrections to comply with the drafting requirements of KRS Chapter 13A. The staff suggested amendment makes technical corrections to the relates to and statutory authority paragraphs in sections 3, 5, 6, 8, and 9 to comply with the drafting requirements of KRS Chapter 13A.
201 KR 36100 E&O amends the counseling compact rules to add and incorporate by reference rules, including the rulemaking on legacy eligibility for privilege to practice and rulemaking on implementing criminal background checks. The agency amendments for the E&O amend various sections to comply with KRS Chapter 13A and amend Section 2 to add the newly adopted rulemaking on fees.
Would you please identify yourself for the record?
Dr. Andrea Brooks, Board Chair of the Kentucky Board of Licensed Professional Counselors.
And Sarah Janes, Board Counsel for the Board of Kentucky Professional Licensing.
Thank you so much. There is a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second without objection, so ordered. There are also agency amendments. Are there any questions or discussion on the agency amendments? Seeing none, is there a motion for approval of the agency amendments? We have a motion and a second without objection, so ordered. Any questions from members on this set of regulations from the Board of Licensed Professional Counselors? Seeing none, please call the next regulation. Thank you.
Thank you.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources. 301 KAR 002-132 with staff suggested amendment, 002-172, 002-300, and 301 KAR 005-022 with staff suggested amendment.
301-132 is being amended to require landowner cooperator permits to be used only on land contained within the access agreement, require hunters to remove any bait 30 days prior to hunting in that area, move the second cow elk gun season to the first Saturday in January, and open Paul Van Boeven WMA and Fish Trap Lake WMA to elk hunting. The staff amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A. 2172 is being amended to change the October youth season from 2 days to 9 consecutive days. 2300 is being amended to establish a 14-day hunting season in Clinton and Wayne counties and add the Siberian Leica to the list of approved dogs to be used during bear chase and the hunt with dogs seasons. And 5022 is being amended to establish non-commercial foxhound training enclosure permits to allow operation of foxhound enclosures of 40 to 200 acres. The staff amendment amends Section 1 to update language for consistency and to comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Jenny Gilbert, Legislative Liaison.
Stephen Field, Staff Attorney.
Thank you. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion. Do we have a second? We have a second without objection, so ordered. Any questions for Fish and Wildlife on this set of regulations? Co-Chair Lewis, almost forgot you.
Thank you, Co-Chair. Every month, guys, every month. Now, I have two questions, if you'll indulge me. Number one, dealing with 301 KAR 2132 in regards to elk. What's our elk population looking like in the state currently?
Our biologists would tell you they feel very confident that it's strong right now. We are monitoring the bull versus cow, but that's part of why you're seeing this baiting change. It's when you hunt over bait, you're more successful. So
Right.
In order to continue to monitor the harvest and how successful people are at harvesting, we just want to make sure there's some fair chase there.
Sure. Second question, dealing with 301 KAR 2172, amending the October youth season from 2 days to 9 consecutive days. What was the basis behind that?
We're just trying to allow youth more opportunity, frankly. It was a request that came to one of our commission members out of the Western Kentucky area. And obviously, well, you know, you're a deer hunter. The population there is pretty dense. And so the discussion was if youth had opportunity before more seasoned and veteran hunters were out in the field, they would probably be more successful. And so if we're doing mentor hunts or people are taking their children, grandchildren out, those kids would have an opportunity to be a little bit more successful or to go back repeatedly within that 7 days if they weren't successful the first day they went out.
Sure.
And then hopefully harvest more deer, because that's
No,
what we need to see. We need to be harvesting more deer. So.
No, I love it. I think that's great. Anything that gets our youth involved. And I know when I first started, I was probably 9 years old or so, and I was a little bit more loud than I back then than I was now, or at least I think so. But no, I applaud your efforts on that. Thank you.
Any other questions? Seeing none, please call the next regulation. Thank you.
Thanks.
Transportation Cabinet 601 KAR 012-120 emergency with staff suggested amendment.
601-12-120 emergency establishes visual acuity and visual field testing requirements for driver licensing. The staff suggested amendment makes technical corrections.
If you would, please state your name for the record.
Jesse Rowe, Assistant General Counsel for the Transportation Cabinet.
Thank you so much. There's a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second without objection. So ordered. Anybody have any questions for the Department of Transportation on this reg? Seeing none, call the next regulation. Thank you.
Thank you.
Education and Labor Cabinet, Board of Education, Department of Education, 704 KAR 003-315 with staff suggested amendment.
This regulation establishes the procedures for the annual certification of non-public schools. The staff amendment amends various sections to correct the statutory citation and comply with the drafting requirements of KRS Chapter 13A.
If you would, please state your name for the record.
Good afternoon. Todd Allen, Deputy Commissioner and General Counsel for the State Board and Department of Education.
Matthew Courtney, Policy Advisor to the Office of Continuous Improvement and Support at KDE.
Thank you. There's a staff amendment. Do we have a motion for approval of staff amendment? We have a motion and a second without objection, so ordered. Any questions from members for the Department of Education? Seeing none, please call the next regulation. Thank you.
Department of Workplace Standards, 803 KAR 002-300 and 2320, which has a staff suggested amendment.
803-300 amends requirements commensurate with federal standards. 803-320 amends occupational safety and health standards in the context of toxic and hazardous substances to revise classification provisions for certain health and physical hazards, update labeling requirements, and establish new provisions for trade secrets, safety data sheets, and definitions. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Robin Maples. Oh, it always looks like it's on. Robin Maples, OSH Standards Specialist with the Department of Workplace Standards. Good afternoon.
Good afternoon.
Good afternoon. Jason Hernandez, General Counsel for the Department of Workplace Standards Legal Division.
Good afternoon. Chuck Strebling, Deputy Commissioner, Department of Workplace Standards.
Thank you so much. There is a staff amendment. Is there a motion for approval of staff amendment? We have a motion. Do we have a second? Second. Without objection, is so ordered. Any questions from members for on occupational safety and health? Seeing none, please call the next regulation. Thank you.
Thank you.
Horse Racing and Charitable Gaming Corporation, 810 KAR 002-070 and 004-030. Both regulations have staff suggested amendments.
810-2070 amends Flat Racing Association provisions to remove the requirement for fire-resistant construction for barns and stalls, allow a first aid area to be attended by a physician and either a registered nurse or board-certified athletic trainer, allow ambulance services to transport or make arrangements for transportation of an injured person, and delete the requirements that racing associations have at least 4 races for 2-year-olds each week beginning on March 1st of each year. 810-4030 amends requirements for entry, subscription, and declaration of horses to allow a horse to be entered in 2 races on the same day if the horse does not participate in the body of both races. Attach allowable mutual entries to common ties of ownership. Clarify that scratched, also eligible list horses do not forfeit entitled preferences if these preferences were previously forfeited after a scratch, and revise entry examination provisions. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Thank you. Jamie Eads, Kentucky Horse Racing and Gaming Corporation. Ashley Bailey, Chief Legal Officer for the corporation.
Thank you so much. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, is so ordered. Any questions from members for the Horse Racing Commission? Seeing none, please call the next regulation. Thank you.
Cabinet for Health and Family Services, Department for Medicaid Services, 907 KAR 001595 Emergency, 003-100 Emergency, 007015 Emergency, 012020 Emergency, and 020005 Emergency.
907 KR 1595E amends to delete and update reimbursement methodology to reflect the approval of new federal 1915C waivers pursuant to federal law, including to allow for higher reimbursement for providers and to conform with KRS Chapter 13A requirements.
907 KR 3100E amends provisions to make updates to the Medicaid reimbursement methodology for acquired brain injury waiver services, increase the federal reimbursement of rates for consistency with new federal 1915C waiver rates, include that the department's coverage of services is contingent upon federal approval and receipt of federal funds, and make technical corrections to comply with the drafting requirements of KRS Chapter 13A.
907-7015 Emergency amends reimbursement provisions for home and community-based waiver services to update the reimbursement methodology commensurate with the new federal 1915C waivers. 907-12020 Emergency amends reimbursement provisions for SCL waiver services to update the reimbursement methodology commensurate with the new federal 1915C waivers. And 907-20005 Emergency amends Medicaid requirements for certain recipients to allow incarcerated children and youth to receive targeted services 30 days before release.
Would you please state your name for the record?
Dr. Leslie Hoffman, Deputy Commissioner for Department of Medicaid Services.
Jonathan Scott, Regulatory and Legislative Advisor, DMS.
Thank you so much. There are no amendments. Do any members have questions for the Cabinet for Health and Family Services? Seeing none, please call the next regulation. Thank you.
This is continuing with Cabinet for Health and Family Services, Office of Human Resource Management, 920 KAR 001090.
920 KR 1090 amends the complaint form to assist limited English proficiency and disabled clients in making a complaint.
Would you please identify yourself for the record?
Jay Klein with the Office of Human Resource Management.
Hit your green button there.
More green.
Yeah.
Jay Klein, Office of Human Resource Management.
Thank you so much. There are no amendments. Any questions from members? Seeing none, please call the next regulation. Thank you.
Department for Community-Based Services, 922 KAR 002020 with staff suggested amendment.
922 KR 2020 amends to update citations and material incorporated by reference, require child care provider claims with an estimated value of $10,000 or more to be referred to the Office of Inspector General, and require the child care assistance program claims with an estimated value of $5,000 or more to be referred to the Office of Inspector General. The staff suggested amendment amends Section 7 to correct addition dates and Section 5 to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Andrea Day, Director for the Division of Child Care.
Thank you. There's a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, so ordered. I do have a quick question on this one. Describe some of these situations where the child care provider would have $10,000 in claims. Just walk us through what's happening here.
Those are few and far between, but there have been instances of that occurring, and our regulation did not clearly identify that. So when working with the Office of Inspector General Audits and Investigation, we put those parameters in place to make it more clear.
Okay. So the cabinet is responsible for paying the CCAP claims, correct? And so if, let's say I'm a provider and I've got $10,000 in unpaid claims or more, why wouldn't it be a question of the cabinet making a determination, either paying or not paying the claims? Why? It seems like, here's what I'm trying to think about and prevent. So let's say, it sounds like all these $10,000 claims and above are going to be kicked up to the Inspector General. Seems like that's an added layer of bureaucracy if it's unneeded. Tell me
we
where
do
I'm
work
wrong.
with the providers before we get to the point of elevating it. We do work with them to make a payment arrangement, whether we are deducting from what their CCAP payment is to them to recoup some of those funds, or if they're going to set up a long-term payment. So these are more, the 10,000 and above are more extenuating to where we've not been able to reach that resolution.
So what would be the situation where the cabinet is recouping CCAP funds?
It could be fraudulent billing, that someone
And that's mainly what this is aimed at?
Yes, sir.
Okay.
This is more about the program integrity and making sure that our regulation is very clear and that those amounts are established.
Okay, thank you. Anyone else have any questions at this point? Seeing none, thank you so much. Appreciate it. That is the end of almost every regulation except for a few. We will circle back now towards the front of the agenda. And next up on the agenda, we will have the Department of Financial Institutions 808 KAR 3050. If you could come forward.
808 KAR 3050 amends provisions to authorize state chartered credit unions to receive a low income designation under federal law and participate in federal programs offered to low income federal credit unions, including accepting non-member deposits. The amended after comments version deletes the exception for non-member deposits of public funds from the amendment.
If you would, please state your name for the record.
Sure. Marnie Gibson, the Commissioner of the Department of Financial Institutions.
And I'm Catherine Adams-Cornett, General Counsel.
Thank you so much. As far as I can tell, there are no amendments to this regulation. If you would, I believe we do have some people signed up to speak against. So if you would, please give us a brief overview of what the regulation is and what it's attempting to do, a little bit of background, if you don't mind.
Okay, sure. So first of all, we did defer this reg again. So it was the main reason for the deferral is we're still having discussions and trying to work through a resolution that's going to be best for all parties involved. So I'm happy to give you a high-level overview of kind of what the reg does. So essentially, we did add on a low-income designation, which is something that the NCUA permits in its statutes, and whether we permit it or not, the NCUA would actually continue to allow that. And we do have a few current low-income designation credit unions, and then we've also included some parameters in there for what these low-income designation credit unions can do. And again, that's pretty simple what it does. Really, that's the extent of it. I will say the low-income designations are something that most states do, and I believe we have over 30 states nationally that do allow a complete parity. But we, again, just decided to put a few things into statute to make it clear what low-income designation credit unions can do. And for informational purposes, a low-income designation credit union is one that has 80% of its members, has 50% of its members below the 80% median income with their field of membership. So it's really just designed to assist the credit unions with serving the underserved.
Thank you. So I have one question right now. So what does that, by giving the designation, what does that mean?
So that allows low-income designation credit unions to do a few extra pieces. One of those, and I'm actually just going to make sure I have the language clear. Katie, do you have that with you?
The language of the reg.
Yeah, I don't have my glasses on, so I apologize.
Take your time. Take your time.
Trying to hold it back to make sure.
So that is.
Yeah, there we go. So there are, there we go. See it now. There. So there is an exception on the statutory cap for member business lending, and the goal of that is to allow the credit unions to do additional member business lending, again, to help kind of the underserved in that area. Eligibility from grants for the Commission for Developing and Resolution for Loan Funding, and that is something, again, developed by the NCUA. To allow the acceptance of supplemental capital, and then lastly to accept non-member deposits. And that non-member deposit piece is so greatly limited to where it's about $3 million total, and there's a special calculation for what allows them to do that. And the non-member deposits would still be subject to the field of membership requirements, so it would just be, again, a small portion. Those are typically a temporary deposit to help credit unions really help with the lending piece, again, going back to that low-income designation. And the credit unions do have to maintain that low-income designation, and that is repeatedly checked and those calculations made.
I did not intend to ask all these questions.
No, you're okay.
Your information is leading to other questions. So
Sure.
What does the supplemental capital mean?
The supplemental capital just allows them to take additional capital from other sources. But
So in other words, tell me if I'm wrong. I go to buy a house and someone wants to lend me the down payment. Could that be supplemental capital? You don't have to. If you don't, that's fine.
I would say no. That's not exactly what Katie.
That's not what that's talking
We
about.
could get you an answer.
Yeah, we're happy to go back and get some additional
fine.
information. I was saying no, but this is more designed on what the credit unions can take, because they have certain limitations and caps on what they're allowed to accept, what they're allowed to hold on their books, and this would allow that to be increased just for the low-income designation. I think that's probably a better explanation than what I actually said. I'm using a lot of jargon here, so I do apologize.
That's okay. We're going to hold questions for now. I guess I was the only one allowed to ask questions right now, but we're going to bring we have some people here to speak against the regulation. I think it's the Bankers Association, I think, is up. If y'all could move over there for just a second. They're going to speak, and then when they're done, I'll allow questions, and then I'll bring you guys back.
Okay, and I'll get my glasses in the
Yeah.
interim so I can see my notes.
that'll
Thank
work.
you.
Nobody wanted to take the center seat. Injured reserve. All right. They may have to call you in. You know the deal. State your name for the record. Make sure your green light's on. Proceed.
Tim Shank, General Counsel, Kentucky Bankers Association.
John Cooper, Government Affairs Consultant for the Kentucky Bankers Association.
Floor is yours.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to testify here today. We prepared a really short PowerPoint deck to explain our position related to this proposed administrative regulation. The first slide here is just the administrative reg itself. If we could go to the second slide. This is really the critical portion of which we are addressing here. As you can see, it's subsection 2 of the administrative reg, and it says the key part of that is highlighted, which says may accept non-member deposits, which has been the critical part related to this administrative reg that we have opposed. Reading KRS 286.6-335, which discusses deposits, it talks about limitations related to credit unions and their deposits. And it says a credit union may offer deposits and deposit certificates to its members and other credit unions. That's the limitation of their deposits related to it by statute. If we could go to the next slide. And then this talks about field of membership, which is really critical when you're talking about credit unions and who they may serve as their customers. And this is obviously all built within part of KRS 286.6. And when you're looking at field of membership on 286.6-107, it says the membership of a credit union shall be limited to and consist of the subscribers to the articles of incorporation and such others within the common bonds set forth in the bylaws as have been duly admitted members, have paid any required entrance fee or membership fee or both, have subscribed to one or more shares, and have paid the initial installment thereon, and have complied with such other requirements as the articles of incorporation or bylaws specify. Looking at the next section there, it says that credit union membership shall be limited to persons having a common bond or similar occupation, association, or interest. So when you're looking at the construction of KRS 286.6, essentially this is field of membership, and the limitations on the statutes under 286.6 are just that, limited to that. So when you look at UK credit union, that's limited to people with UK affiliations. There are all sorts of examples related to that, but that's the limitations. What's not noted in 286.6 is taking any deposits or anything else related to non-members. And if we can go to the next statute there. It says, this is just talking about where we are. And again, 286.6 prohibits credit unions, all credit unions, from taking any deposits from non-members. And obviously, if there's, as you all in the committee know, if there's something promulgated by statute, there cannot be an administrative reg promulgated in contravention of statute. So it's our opinion, members of the committee, that in order to promulgate this regulation, there'd have to be an amendment to 286.6 allowing for non-member deposits. And that's simply not contained within that herein.
Floor is yours, John.
I'm good.
You good?
I'm good.
Okay. I believe Co-Chair Lewis has a question.
Yeah, I have a couple questions. So obviously, I mean, you're making the case that efficiency exists. Probably, I mean, I guess the reason would be that it is in conflict with existing statute would be your argument, correct?
That is correct, Mr. Chairman.
How have your conversations been? I know I've talked to the commissioner, and I appreciate all the work that she's done on this issue, and you all as well. I mean, is there, outside of passing new legislation in your eyes, is there any room for compromise on this language?
Mr. Chairman, we have met multiple times and had a lot of discussions with the credit union groups and also with the commissioner on this. And quite frankly, I don't think there's anything that we can do, in our opinion, outside of a statutory amendment from the General Assembly. If there's one exception made, allowing credit unions to accept non-member deposits, this is going to leak over to all forms of credit deposits. I mean, credit union deposits, which is a big concern amongst the bankers and, quite frankly, in contravention to the statute.
Okay. I guess the only other question I'd have is over the interim, you know, depending on what happens here today, over the interim, would you make a commitment to this committee that you would be willing, that your organization be willing to meet with the commissioner, with the credit unions, and should there be any type of resolution to accomplish what they're trying to accomplish? Because I mean, I am, you know, I do have sympathy for low income, but I do understand the statute side as well. Could we get a commitment from you all to work together with them in the interim, or at least have conversations?
Absolutely, Mr.
Absolutely.
And we have committed to continue to talk to the credit unions, and we do talk to the commissioner on a regular basis.
I got one question. Any other members have questions? I'll let you go first if anyone else has anything. While we're here, I'm going to ask you this question. I may ask them the same thing. When it says, you know, non-members, in your opinion, you know, what does it mean to be a member? What does a low-income person or a depositor have to do to be a member of a credit union? I'm assuming it's pay like a a small fee to become a member, sign up like you would to open any type of account? What's your opinion on that?
Thank you, Mr. Chairman, for the question. So credit unions are built a little bit differently. Essentially, they're owners of the credit union. So if you look at, for example, a Fort Knox credit union, you'd have to be part of Fort Knox to be part of that credit union. And you essentially, my understanding of credit unions is that you buy an interest in that, and therefore you're a shareholder and a member, and then you're part of that credit union. Obviously, there's big concerns nationwide, statewide, as to expansion related to that. And if you look at the original, without going into the original purpose and going into all sort of contextual things related to credit unions, but that's the big concern here.
So as an example, you have UK Federal Credit Union. When I go in there to open an account, I don't have to go to UK. I don't have to work at UK. I can become a member of UK Federal Credit Union. I would call it a membership fee, but it's a share. You're buying a share. Like I'm a member of Farm Credit Services. You're buying a share, and so to the other side, their point is that maybe sometimes that share may be too costly or whatever. But most generally, wouldn't that share be a really small amount in your opinion, or can you speak to that?
Mr. Chairman, I honestly don't know of what a membership fee may be. But obviously, there's all sorts of arguments of where those fees are going, and
there's all sizes of fees depending on the type of credit union you have. I got you. Any other questions for this set of guests? I'm going to bring them back up at this point and let them.
Thank you, Mr. Chairman. Thank you, members of the committee.
You're welcome. If y'all would come forward, you can. Before we start, got your glasses? That's great.
Found my glasses. Now I can actually see.
All right. Before you get into I'm going to allow you to, rebut testimony. But where we left off there, what would be an example of these fees to become a member? Do you know approximate size, cost, those sorts of things?
Well, so every credit union is a little bit different. Federal credit union is a little bit different from the state charters. Generally, it is very minimal. So when you say that it's a small amount, yes, it typically is. $25, $10. Some are even just a few dollars. I'm sure there are others that are much larger than that, but it is a very nominal amount.
And so there's nothing. I'm just going to use UK Federal Credit Union as an example. So there's nothing that holds back anyone in Lexington from becoming a member of that credit union except the $25 fee.
Correct.
And if they paid the $25 fee, a lot of this becomes moot.
Correct.
Because they would be an official member.
Correct.
Okay, gotcha.
Yes.
I just want to make sure in my mind what we were doing here. Okay.
Yes.
The floor is yours. Feel free to rebut any testimony that's been given, and we'll open up for questions at the end.
Sure. So I will just say I do appreciate the comments from the Bankers Association. They have definitely reached out and have continued to try to work with us. And I think the goal is for all parties to continue to work together. So I do appreciate that very much. Just a couple comments that I think are less rebuttal and more clarification is that the way the low-income designation is written, the field of membership would still be intact, and I think that's a big issue that we do see. In Kentucky, the field of membership for state charters is very limited, so I know there are federally not so much, and some states may have a statewide field of membership, and we do not. It's very limited to a common bond. So these non-member deposits would still be, from the way that we read this and the way that the NCUA statutes are written, would need to still fall within that field of membership. And then a second point that I did not make is that those non-member deposits are subject to certain limitations as well. And here's where I'll get my glasses, because I did write that down just in case. For example, they can only be used for certain purposes, such as lending, for example, or to, I guess, really work for those purposes of the low-income designation without getting too into the weeds. Again, they are very, very limited on what they can be used for. So, for example, they couldn't be used to pay back interest to members, for example, or pay on those shares. So again, the point is that those non-member deposits are used specifically for a certain amount of certain purposes, which are listed in the NCUA regulations. And part of the issue is these are NCUA regulations that we are sharing and that we are trying to, I guess, respond to questions in regards to. So I hope that's a little bit helpful.
It is. It is. Anyone else? Senator Wilson has a question.
It just brought to my mind, excuse me, because I've been a member of a couple of credit unions, and my mom was, but I don't know if she was a member or not, but she had IRA and things like that she would find out what they were paying, and she would utilize different banks or credit unions, and so she did, and I'm not sure if she had to join. Is this something that a non-member could actually do under that scenario?
Only if the credit union was designated a low-income designation credit union. So for your regular, we'll just say a standard, I'm going to use standard. For a regular standard credit union, she would have had to become a member of that credit union in order to put her IRA or her deposits or utilize any of their services. I think there are a few limitations such as check cashing, but again, nothing related to the question that you've asked. So for example, a non-member could use check cashing just like a person that does not isn't a bank account holder, for example, could cash a check for a fee. So very similar, but that's really the only thing currently that they can do. Credit unions can hold non-member deposits for other credit unions, but that's really the only, unless I'm missing something, that for currently the way the statute is written for a standard non-low income designation credit union, she would have had to have been a member to utilize those rates.
Okay, thank you.
You're welcome.
In Senator Wilson's example, would his mother have to be low income?
No, just the credit union itself.
Gotcha. Any other questions from members? Co-Chair Lewis.
Thank you, Co-Chair. Commissioner, again, I appreciate all your work, and I'm not saying that this isn't warranted. I think we need to look at it over the interim. However, when I look at the statutes going back to 286.6, I believe this is in conflict with existing statute. But I do think this might be something that both parties can work on over the interim, and I do appreciate all the work on both sides that's gone into it so far. But Chairman, I will be making a motion to find 808 KAR 3050 deficient. I would request a second.
We do have one additional piece of information, if we could share that. There is one additional statute that we utilize to bring this regulation forward.
Right, I noted when we draft this, the regulation, KRS.
Could you make sure that Mark
I apologize. I think I was a little too far away from it. KRS 2866095 states that notwithstanding any other provision of law, the commissioner may make reasonable rules authorizing credit unions to exercise any of the powers conferred upon federal credit unions if the commissioner deems it reasonably necessary for the well-being of those credit unions. And that's what we cited as authority for promulgating this regulation.
I appreciate that. And again, I would also say this subcommittee has the ability to find any regulation deficient if it appears to be deficient in any other matter. My biggest thing, I think you're looking at good policy, potentially good policy, but I think both sides need to come to the table. We're getting ready to be done with session. If there is something that we need to do to allow you to do this, should it prove to be good policy, I'd be willing to work with you on that way, but my motion still.
Thank you for your presentation. Absolutely. We do have a motion on the floor to find this regulation deficient. We do have a second. Is there any discussion on the motion for deficiency? Seeing none. Question on the motion is to find the regulation deficient. All those in favor of finding the regulation deficient will vote aye. Those opposed will vote no. Please call the roll.
Senator Rocky Adams. Senator Mike Wilson. Senator Yates. Representative Bridges. Representative Gordon. Representative Marzian. Senator
Representative Lewis, pardon me.
Yes.
And Senator West.
Aye. There being 5 aye votes, 1 no vote, motion for deficiency has passed. Thank you so much. That concludes this particular regulation.
Thank you.
Thank you.
Appreciate your allowing us to present on the matter.
Thank you.
you.
Up next, we have the Energy Environment Cabinet. 405 KAR 10001 and 405 KAR 10015.
401-10001 deletes the definition for long-term treatment. The amended after comments version redefines long-term treatment as the use of any active or passive water treatment necessary to meet water quality effluent standards. 405-10015 amends the criteria for reclamation and performance bonds for surface coal mining operations to revise incorporated material through which the division would recalculate long-term treatment bonds to ensure that the agency has funds sufficient to cover the cost of discharge treatment in the event of a forfeiture.
If you would, please state your name for the record.
I'm Gordon Sloan, Department of Natural Resources Commissioner.
Dawn Basie, an environmental scientist consultant under the Commissioner.
Wesley Jones, Director, Division of Mine Permits.
Thank you so much. There are no amendments to this set of regulations. We're going to camp out here for a little bit, so I'll just warn you. If you would, just go into a brief overview of what the regulations do.
Sure. The regulations are required because we have promulgated other regulations in the past, but according to the Surface Mine Control and Reclamation Act of 1973 and our own statutes, the Department of Interior, the Secretary, must approve our regulations before they can become effective. So in the past, we have promulgated several regulations, but they haven't met the approval of what's called the Office of Surface Mining Reclamation and Enforcement. Primarily, the definition for long-term treatment is required because there are such things as, especially acid mine drainage, that can persist for quite a long time. So we, as the DNR, we prepare a bond that the coal company must put up, and that's been one of the issues, is that we used to have what was called a 20 multiplier, and that is whatever amount the coal company would spend per year, we would multiply it times 20 and say that's the amount of the bond that we require. Again, the Secretary of the Interior found that deficient because it did not take into account that the long-term treatment may continue into perpetuity. That is quite a long time, but which they tell us must be at least 75 years. So that's the definitional part. As a matter of fact, what is defined in the current regulation is phase 1. Whenever a coal mine finishes, it has to be reclaimed. Phase 1 is that first part of reclamation that requires backfilling of any high walls, grading, installation of drainage, seeding, things like that. So that is what's in the current regulation, and so the Secretary of the Interior said that is not sufficient either, because the bond must be put up at the time that you observe the long-term treatment need. So that's most of it. The calculation that we have put into 10015, 405 KAR 10:015, there is a calculation form that was approved, actually, finally, something by OSM that was approved, and that is the one that calculates the bond into a perpetuity that is approved by OSM.
Anybody else want to chime in? Okay. Was this, I got two or three questions, then I'll open it up. So was this something that's is required by the Biden administration to promulgate and to do?
It was first required in 2012. Then once we prepared regulations, those regulations were denied in 2018. And so we have now put these new regulations together for approval. They've not been yet, except for the calculation of the bond, the calculation form. Nothing in these regulations have been yet approved by the Secretary of the Interior.
So that they were, in 2018, they were denied by who?
That would have been by the Office of Surface Mine Reclamation and Enforcement.
President Trump was president then.
Gotcha. Under the Trump administration in 2018.
Right.
Gotcha.
Right.
Gotcha.
2022, OSM granted an approval amendment, and that was under the Biden administration. That's the most recent action.
Gotcha. So, off the top of your head, do you know approximately how many coal mines we have left in Kentucky? Just a general idea is fine. I don't need to know an exact number.
As far as active mines, is somewhere around 100.
100, okay.
That's out of almost 1,300 permits.
How many of these mines or mine permits would be required to post this new bond of those 100?
Roughly about 10 or 15 of those.
Okay, so
Pardon me, Wes. How many do we actually have now?
There's 88 permits out of the 1,300 that are required to post long-term treatment bonds. Active coal mines that are actually producing coal, that's a very small handful.
Gotcha. Okay. What would be the approximate cost, you think, to that grouping, to the mines that are actively producing? What would be the new cost, increased cost of the bonds?
I mean, they range depending on the water quality, the situation. Could be as little as, 10, 20,000, or it could be as, as much as, in one particular case, probably several $1 million.
Yeah, the numbers we're receiving on our end are 100 million. Do you think
that would be in total? That's everything, not on one particular operation.
Right. That's what I'm asking across the board, the state of Kentucky.
Yes.
So
that's correct.
So in effect, this particular regulation, if allowed to flow, would be an additional $100 million in costs, new costs, to the coal industry. Is that? Am I fair in stating that? Is that a fair statement?
It would be a bond increase. As far as the actual cost, it depends on the rates that they pay for the bond.
Per surety bond, correct.
Right.
Correct.
Right. There are outliers, one in particular that costs $36,000 a month for the LTT treatment. So not many of those are that high, but that is the outlier. We haven't verified the $100 million number, but it could be quite impactful.
Is it safe to say that this would be a significant new cost to existing mines?
For the ones that have acid mine drainage, yes.
Gotcha.
It is important to note that some of the long-term treatment bonds have actually decreased after we recalculated them.
Okay. I'm going to pause here and open it up. Does anyone else have any questions? Co-Chair Lewis.
Thank you, Co-Chair, and thank you all for coming today. I know this informational session's new. In tracking the good legislation that is coming over from the Senate, of course, we do have Senate Bill 89. I assume you all are aware of Senate Bill 89.
Yes, sir.
And a lot of the filing, I can suspect, is because of this regulation. But you are aware that it would have the effect of repealing this regulation should it go into effect.
And therein lies the problem that the Secretary of the Interior would not approve it, as they've disapproved the actual language already in essence
Okay.
through our regulatory proposal.
Yeah, I think we've deferred this until April in order to find out the fate of Senate Bill 89. That way we could make amendments or adjustments as we need to.
So should Senate Bill 89 pass, if you'll indulge me, Co-Chair?
Please proceed.
Should Senate Bill 89 pass, do you plan to implement the provisions in that bill?
Yes.
Yes.
Okay. Thank you.
I'm going to get a little bit into the actual bond itself. Are there a lot of surety companies out there willing to write these bonds currently?
I'm going to say there aren't a lot of them, primarily 3, 4, 5 maybe.
Gotcha. Do you know what their collateralization, do you know what collateralization is normally required on those bonds?
I mean, all I have is hearsay from people in the industry telling me that most bonding companies are requiring a large amount of capital.
Gotcha. So upfront liquidity in capital to back up the bond. Okay. So, but the bonding industry, you didn't talk to anyone in that industry when you promulgated. Okay. So is it safe to say, is it your opinion that maybe the new administration might take a different tact on this once they're up and running?
It's possible.
Gotcha. Representative Bridges has a question.
I'm just trying to get this in perspective. And I'm looking, do you know what the severance tax was in 2023?
I have no idea.
We've done some research on that, and the way it looks is this would, with these additional fees and everything, just about double that on the coal industry. What's that going to do to the competitive of a coal compared to other states when you do this, if this were implemented?
It's hard to compare our state to other states. There are so many differences in the way we regulate, all under SMACRA. But there are just a lot of differences. I apologize. Wes, did you have any thoughts?
West Virginia is much different as the state absorbs those costs. Pennsylvania, they use water trusts, so it's quite a bit different than what we do.
So I'm going to piggyback on to Representative Bridges just a second here on his line of questioning. So I think I hear you answering the question I was going to ask. Do any other states do it this way? Is Kentucky the only state? Let's say this new regulation goes into effect. Is any other state doing it this way?
They all seem to be doing things differently, not the same way.
Okay.
Some have a trust that they've instituted probably some time ago. Others, we've looked into it, but it's hard to compare.
Gotcha. If implemented, do you think this will cause a certain number of coal mines to go out of business?
That's a possibility, but again, most of them don't have this long-term treatment issue. Those that do, they can appeal it to our Office of Administrative Hearings.
Gotcha. Any other Representative Bridges?
I've just got a follow-up question. Do any other states have a long-term treatment regulation such as this? And if so, who are they and how do they line up?
As far as we know, I don't think anybody has a long-term treatment definition or specific calculation. It's all related to pollutional discharges, water pollutional discharges. But as far as I know, nobody else has that definition, long-term treatment, that is specific to Kentucky.
So follow-up question?
Please proceed.
So it can be assumed that the long-term treatment is not even used in the federal surface mining control?
Right.
They use acid mine drainage.
Yes.
But they don't use long-term treatment requiring a...
I mean, what Pennsylvania does is that they use a trust that's set up where it's administered by a third party, like some kind of stream group or something like that. And they calculate 75 years, as far as that's the amount that's put into trust, then that's reevaluated every few years to see if that's still adequate. West Virginia, the state themselves do the treatment, their Division of Abandoned Mine Lands. That's incorporated in the fees that they charge the coal industry.
Let me also mention that when we had the discussions with the Office of Surface Mining Reclamation and Enforcement for our calculation method, they determined that a definition of long-term treatment was not necessary.
Are you done?
I'm really confused now.
Does that mean you have another question?
Well, if they say it...
I may be able to clarify. I hope I understood your question.
I mean, in one sense you're saying it's not needed, in another sense you're saying they're saying it's not needed, so I'm confused here.
Every state has to account for any water pollutional discharges. Every state has to have that. Ours is just called long-term treatment. It's something we've actually tested that term for Kentucky only. But all the states have to require the same type of bonding to sufficiently take care of that issue if it becomes one.
Yeah, I mean, OSM's position is that you have to treat, if you have to treat when you become aware that there's an acid mine drainage problem, that's when you have to, bond for it.
I guess my concern is...
Please proceed.
That our cabinets, not just this one, but many of them, have instituted more strict and stringent regulations than what the federal are. I know on the legislative branch we're attempting to realign them and go back to just what the bare minimum is, and I'm afraid this is it's one thing when the federal level attacks our industry. That's it's just hard for me to see that we're going to work with them to continue to attack our coal industry. So that's just an observation, but I'll leave it at that.
May I respond?
Please proceed.
Yes, thank you. We have been dealing with this since 2012, and we have proposed several edits of regulations that the federal OSM has found deficient, explicitly that they have found deficient. We would not do this were it not for the fact that all of these regulations have been found deficient, except the one with the calculation method.
I've just got one question. I know you said it was found deficient, 2012, and then it come to 2018. What is the penalty from the federal to us during those times that it's deficient? What has our penalties been to the federal?
We have not had any financial penalties, but there is always the possibility that the federal program can take any part of our program away from us. They have not done so yet. They haven't threatened to do so, but that's always a part of SMACRA.
Yeah,
Okay.
I mean, the risk is that they could step in and calculate bonds for us.
What are our companies, just to be clear, this proposed language is additional bonding over top of existing bonding that coal companies are doing. So what are our companies currently paying as it may be a lump sum number?
Well, I mean, right now they're using, most of the bonds we have in place are based on an annual cost that was calculated back in the 2014, 2015 range, and that's multiplied by a factor of 20.
So do you have a total number, a running tab of what, coal companies as a whole are paying for bonds?
We pay, or they pay, several different kind of bonds. On the permit itself, outside of LTT, there are several different bonds that can be assessed. Wes, you'd be more familiar with that.
Yeah, I mean, I don't have a number in front of me, but I could run some numbers when I get back in the office and tell you the total amount of bond that's currently posted.
Gotcha. Any other members have questions? Okay, I'll hopefully try to end this out here, but I think generally speaking what we're thinking at this time is we're not comfortable with waiting on this. We feel, let me rephrase that, I feel that this is a significant impact on the coal industry. Could, in effect, put many companies out of business at a time where we need energy, significant amounts of energy just to keep up. And we do have Senate Bill 89, which kind of lays out the current will of the legislature. That is in the House, and that's issues are being worked out there. I know that's the case. We have a new administration coming in Washington, so obviously any new administration will have a different tact on things. And so for those reasons, I don't feel that we have an opportunity or any choice but to find these regulations deficient. And before I make a motion, do we have any discussion? Co-Chair Lewis?
No, I'll echo your concerns. I was waiting for you to make the motion.
I make a motion that we find these regulations deficient.
Second.
Any question or discussion on motion for deficiency? Seeing none, the question on the motion to find these regulations deficient, all those in favor of finding the regulations deficient will vote aye. Those opposed will vote no. Please call the roll.
Senator Rocky Adams. Senator Wilson.
Aye.
Senator Yates. Representative Bridges.
Aye.
Representative Gordon. Representative Marzian. Representative Lewis.
Yes.
And Senator West.
Yes. Motion for deficiency passes unanimously. That concludes the regulations for today. Thank you so much for your presentation. We really appreciate it.
Thank you for having us.
Yep. Do we have any other information? Please proceed.
The next committee meeting is scheduled for Tuesday, April 8th at 1 p.m.
Tuesday, April 8th at 1 p.m. Please make note. Any other business to come before the committee? Seeing none, do we have a motion for adjournment?
Motion.
This meeting's adjourned.